good things are happening in Jamaica. Our unemployment remains the lowest it has ever been, which means more Jamaicans are working and can provide for themselves and their families. Your government is building Jamaica. We care about our minimum wage earners. That is why we increased the minimum from the previous increase of 13,000 to now 15,000. And as our economy continues to improve, you can look forward to even more increases. Your government is caring for you.
No, that represents the apologies for absence. I'd like to welcome members to the recommencement of discussions on the various submissions from the public with regards to the amendments to the Integrity Act. Members will recall that we had done substantial work up to when we broke and had covered just about 39 sections of what would be, I think, 57 or so. We had reached the point of dealing with declarations, and we wanted to pick up from there and to continue. We also have to bear in mind that there are some referrals that were made for which information should come back to us, and we look forward to get those. It is my intention, excuse me, it is my intention to have this entire exercise completed within this session of the parliamentary year, so that a full report could be ready for Parliament for the new session and for the debates to ensue thereafter and the necessary legal adjustments to be enacted. In my opening remark, I want to thank the members who have worked very hard on this Joint Select Committee so far, and particularly Ms. Douglas Clark, who has been quite assiduous and been with us throughout, the team from the Solicitor General's Department, and also our own legal support team here and the Attorney General and the Attorney General's Department, and to indicate that we are committed to ensure a completed program within the time I indicated, but we want to assure the public that there will be no cutting of corners in any way whatsoever, that we will work diligently and carefully to ensure that the work is done and done in time as indicated. I want to also, in my opening remark, recognize 30 students and 3 teachers from the Effortville Primary School in Clarendon who are here to join us today from the gallery and to witness the Committee of Parliament at work. I think the selection of the Joint Select Committee on Integrity Commission Act is a very important, in my mind, a very important window through which you could understand the workings of the committee system of Parliament. And I hope that you will benefit from your visit here with us today. Welcome and all the best. I'm being guided on one point of correction here, that also the Legal Reform Department is involved with us in enabling us to have the very best review possible of the sections of the Act, and I want to thank them and to include them in my remarks. Well, I see a member has joined us who has the right to attend, you know, so don't worry. Every member has the right to attend any committee meeting of the House. The point to remember, however, is that you don't have a vote. The minutes are before you. Yes. Well, member.
Chairman, may I respectfully suggest that the minutes be deferred to a later stage of the meeting, not necessarily to another meeting, because we do need to get through the minutes. I am part way with my own review of it. If it finds favor, perhaps members would concur for the deferral to a later stage of the meeting.
The proposal from Member Malahoo is for a deferral of the minutes at this time in order to allow members to fully read through and digest the contents therein, and possibly for us to have the minutes taken at a later point in today's session, and if not, to defer for another meeting. Have I interpreted your position well, Madam Member? Thank you very much. Does that meet the approval of the committee? Yes, thank you very much. So the need for matters arising then would not obtain, and let's move straight into the review of the Integrity Commission Act. The matrix are before you, and Member Malahoo Fort, I'm going to call on you to be the narrator in this respect. Normally, Mr. Chuck helps us along with that, but I'm going to ask you to do so today. So, Ms. Douglas, we are at section 39, are we? No? Page. Yes, I know, and the ones we said that were deferred we'll come back to. But yes, I think we had reached that at the section dealing with declarations, right? And we had 39, yes. That's page 38, team, the main matrix. And I think we had dealt with the proposal from the PSOJ. If my memory serves me right, Ms. Douglas, you can help me. Yes. And that was accepted with modification. Okay, so here we are. So page 39. We start at 38, yes. At the bottom of 38, Member Malahoo Fort, please guide us.
I thought we had said before, because of the absence of so many members, we'll postpone till we have them here for some discussion, because there's 3 of us here now.
Yes. Member 4 is a quorum, and with 4 of us being here, we're constrained to have the meeting. We may, in the process, decide whether we would make decisions if we wanted a larger number, but we certainly have the quorum to go through the investigations and to make recommendations. If not, in fact, we can take decisions, but of course, as I said, it's up to us to decide on that. My own take on the matter is that I am guided. I'm guided by the members, because I do appreciate that several of our key members also are not here today, who I know have opinions on some of these matters, and they are often government business, and 1 or 2 are not so well physically. So I'm guided by the committee in that regard, whether we do take decisions or we just review straight and then hold decisions for the next meeting. Is there?
If we're going to continue, can we revisit any item that we had looked at before?
Well, we wanted to remember the items that we looked at before have all been placed in the referral group, meaning there are technical guidance that we're to get. There's the Solicitor General is to come back to us on, some our own teams are supposed to come back to us on, and some of it we have put for further references later on. So all of those will have hopefully to come to us during this February session that we meet, because we have to complete the whole exercise within the 4-week period that we have ending February of this year.
Page 34 and 35.
Sorry, member. Member Guy wanted to make a comment.
Chair, I'm inclined to agree with the latter part of the suggestion that you make, in that we can discuss, but in terms of making decisions, we could, well, yes, but even then, we can still discuss. But I don't think I would disagree with my colleague to my right that we should go over matters that we had looked at for review. I would prefer if we have a more fulsome grouping of members here to look at those other matters that have been deferred and also to be sent back to us for decision.
I think we have been very significantly strengthened. I think we have been significantly strengthened by two members who have just arrived, and therefore I think we are fully constituted and in good order to make the right decisions as we move forward.
I was asking on page 34 and 35, I don't recall these items being rejected, or these recommendations being rejected.
Yeah. So member, in keeping with what the tradition has been, we try to finish and then we go back to the areas that we had asked for referrals. Okay?
No, not referral. It says here not accepted. I don't recall.
No, but when it's not accepted, that's a decision.
I don't recall meeting a decision then. If I recall, there were about 3 members here today.
I see. Okay. The minutes could help us there, Ms. Douglas. Page 34.
34 and 35.
Let's see what 34 said. At the bottom of 34, right? Can you help us?
Look at 34, 35. Yes.
On the matrix? And that was what? The recommendation from everybody or just a specific recommendation?
That's a recommendation from me. It deals with section 34, that where I propose to return the prosecutorial authority to the Director of Public Prosecution.
Oh, you're on page 30. Yours is on page 35. Do I have it correct now? It is being proposed to amend section 36, and the second schedule, section 36(4), states that a report submitted to Parliament shall exclude matters that may, if included, prejudice proceedings in relation to any matter referred therein, and shall not contain any communication which is subject to legal professional privilege. Is that the one you're talking about?
That's the second. The one before was on page 34, has to deal with the DPP and the Director of Corruption Prosecution.
And that the Act makes the Commission a Commission of Parliament. Accordingly, it reports to Parliament, enjoys the privilege of Parliament. If that is the case, then section 36(4) above is of dubious validity and should be deleted. I recommend that we refer this to the Parliamentary Council for an opinion.
That's the second one.
And the indication here is that it was not accepted.
I don't recall that being accepted. I'm going to ask that these items be revisited, that this is not the only one. The other one has to do with prosecutorial authority.
Well, I think what you could do, member, is to make a note for separate cover
I've already done so.
The items which you may have a differing view on in terms of the status.
I've already done so.
And then let us know for future reference. But
It's page 34.
but we want to proceed. We want to proceed. Yes, but we want to proceed with the matrix as indicated earlier. Yes. Member Malahoo.
We are on 38, bottom of Part 5, Statutory Declarations, Section 39. This relates to the duty of parliamentarians and public officials to submit statutory declarations. The submission from the Integrity Commission. In Section 39, it is proposed that due consideration be given to amending the Act to require declarations from parliamentarians in relation to membership in political, trade, or professional organizations, contracts with the government, directorships or beneficial interest in corporate bodies, and other government boards, beneficial interest in land, trustee or beneficiary of a trust, and any other substantial interest that may result in a potential conflict of interest. The rationale is that it will assist the Commission's efforts to detect and investigate matters relating to actual, potential, or perceived conflict of interest and nepotism and other corruption-enabling acts. Discussions in tandem with the recommendation from the PBCJ, given that they were the same areas on which the recommendations were being made. So the additional matters to be declared. Chairman, since it's been such a long time since we met, you would see that the discussion on Section 39 is actually set out on page 2 of the minutes, page 2, 3, over into 4. Yes.
And indeed, it was a very extensive discussion. I don't know that we necessarily want to go over it. So in fact, we had gone through, if you recall, 42. We did 42. And so we could start at 43, in fact, yes. Thank you very much for that. You see, which is why the minutes is so important that we would have gone through. Yes. Member Warmington.
38, 39 that we have dealt with. It says they're deferred until a member is in attendance.
Yes, but
this has to be 39.
Right.
Where I'm recommending that Section 39 be amended, whereby the director, the executive director and all the directors and the commissioners be required to make statutory declaration. Mm-hmm. And as such, this declaration is made to the oversight committees through the Speaker and the President of the Senate.
Right. Because
as it stands now, those persons are excluded from making declaration because they can't declare to themselves. So I'm asking that the team of the Integrity Commission be required to make statutory declaration annually. And they made to the Oversight Committee through the Speaker and the President of the Senate. So Member
Warmington, I think that was discussed and it was deferred. So we will remember, we agree that we're going back to those items which are deferred and those for which we sought further and better information and guidance from technical teams that are supporting us. So don't be deterred. We're moving forward. So, Member Malahou-Fort, you're quite correct. Let's go to 43, which would be offenses in relation to statutory declaration and punishment. On page 43 at the bottom. Marlene? Deferred, yes. Claro?
The proposal by the Integrity Commission for Section 39, you say it's deferred. But I was just wondering, I don't know of any law that requires anybody to declare that they are a member of a political, trade, or professional organization. This would include, like, let's say, in a union. I don't know of any law that has ever required that. Perhaps maybe in apartheid South Africa. Just saying, there's a freedom of association. Why would you be required to declare that you are in a trade union or in a professional organization? And how is that tied back? How is that tied back to the purpose of the act? Because you would have to look at the purpose of the act to see if it meets the test. This kind of just seems very onerous, and I don't know if it is justifiable.
Chairman, I agree with the SG on that, but also I'm just wondering, the presentation from which this was extracted, could I just ask that the clerk just check to make sure that the extraction that is put here in the matrix is correct? And the reason I'm asking that is because there's a little bit of absurdity to the request. The request is saying that the commission itself is asking that Section 39 be amended to require declarations from parliamentarians in relation to membership in political, trade, or professional organization. But by definition, all parliamentarians have declared their membership. That's how you become a parliamentarian, through the party system that is elected and the opposition party system that appoints in the Senate, etc. So by definition, it's done. So I'm wondering if we've had an error in transcription, because it seems absurd.
Okay, so she is checking. Can we move forward while she checks? Yes. Right. Absolutely, and especially that we have agreed that these are matters that we will definitely come back to and be definitive on as we move forward. So I really would urge that we proceed. We need to finish this matrix, and I think we're doing well so far. Member Malahou-Fort, can you guide us? 43. Yes.
Section 43 on page 43. Offenses in relation to statutory declarations and punishment without prosecution of offenses in connection with directions. The submission from Jamaicans for Justice is for an increase in the fine to $2 million, increase in the term of imprisonment to 2 years, insertion in the provision or to both fine and imprisonment, to allow discretion in applying the same. Section 43, subsection 2, they say speak to knowingly giving false statement in a declaration or false information. Inquiry should be treated as a corrupt act in and of itself. Similar offense under Section 2 within the Corruption Prevention Act should also be amended. The proposed liability for the reference section in the two pieces of legislation will now reflect fine and terms as allowed under Section 15(1) of the Corruption Prevention Act. So the JFJ is essentially proposing an increasing in the fine, and that it would be fine and confine. And the rationale is that the fines and penalties under Section 43, 1 and 2 are not strong enough deterrence for committing an offense for misleading, obstructing, or non-compliance. If a public official is corrupt, then the penalties, as written, is almost a safeguard where one simply pays a fine for ill-gotten gains. Accordingly, all aspects of obstruction of justice should be fully criminalized with proportionate and dissuasive fines and sanctions that take into account the gravity of the offense and the damage. I see there are some S's added, perhaps by typo. Subject, predicate, disagreement. Fines are, yes. All right, so the essence of the submission from JFJ is to increase the fine. We have recommendation from BES, the Morning Connection, in relation to 43, that fixed penalty payments as an alternative to criminal conviction should be removed. The offense for failure to file a declaration is far more insidious than it appears and should not be addressed in the manner as though it were a road traffic offense. The reason for non-filing can be yes, I'm looking. Yes, the very root of the corruption we are seeking to unearth and dislodge. Huh?
But just on that last point, the Integrity Commission Act does not have a fixed penalty regime. And the offenses, I see a comment about fully criminalizing them. They are criminal offenses. It's a fine or imprisonment. But that last one that spoke about removing the fixed penalty regime, there is no fixed penalty regime.
It appears to me that there is some confusion on the provision where a fine is to be paid until the liability is discharged. And it is designed to be punitive, so you have for every day or whatever the period is that you're late. But, I mean, a crime is a crime.
Yeah.
Where an offense is...
So, Marlene.
Just to say, though, that these penalties are consistent with other similar offenses in other legislation, right, where you have providing false information and so on. They're in line with similar offenses in other acts. So unless it is that they think that it's just way more egregious here, as opposed to, let's say, under the Revenue Administration Act or
any other.
Because we have been trying to make sure that we have some consistency across many laws. So every time we have brought new legislation or amending legislation, these penalties have pretty much consistent across the board. So to change it, I think you would really have to have a rationale.
Good. Well said.
Thank you, Chairman. Is it that they are recommending, therefore, that the quantum of the payment be increased, in that you have $500,000, they indicate they want to go to $2 million. Yes. But in 43.2, there is a $2 million for a person who knowingly fails to or makes a false declaration, a false statement in a statutory declaration. So are they suggesting that the 43.1C be moved to $2 million? And what is the suggestion for 43.2?
That's the recommendation, it would seem. And when you read what is their justification, they try to relate it to the egregiousness.
I understand, Chair,
Yes.
but what is their recommendation 43.2 then? Is it the same $2 million? Because $2 million is already here.
Right. But we can't quite enter into their minds. So we have to be guided by what is before us. Member, I have two requests. I think, yes, the first was Member Campbell. Yes.
Okay. Chair, my comment was in relation to the Best FM submission. And what I understand the submission to be asking us to do is to remove the ability to make that payment of a fine in lieu of prosecution. But what I think may be misunderstood in what they have said here is that it's not that you get to pay a fine like a road traffic offense. Right. In the road traffic scenario, you have committed the road traffic offense, you get to pay the fine and you're discharged. Right. That's not the case in 43. What 43 says is that the director of, is it complaints or is it investigation? Whichever it is. Pardon? 43.3. Right.
The Director of Information and Complaints.
Right. The Director of Information and Complaints yeah. gets to yes, there is a fixed penalty, but what I'm saying is Best FM is suggesting that it's a fixed penalty in lieu of prosecution and the matter ends there. That's not what the provision says. The provision says that if you have failed to file your statutory declaration and you are given a notice by the Director of Information, is it the Director of Corruption Prosecution, that you're going to be prosecuted, that you can you can afford yourself the opportunity to discharge the liability for that conviction by paying a fixed penalty. But it's not just paying a fixed penalty. You then also have to file the declaration that you have not filed. Yes, so you don't get to pay the penalty and still not file. You pay the penalty and you file. And if you don't file, then they can continue the prosecutorial pathway to the court. Right. So the concern that Best FM has, I believe, is dealt with by this 43.3 thing. So I would say that their concern has been satisfied already by the existing provision.
I tend to share that view. Do we have a consensus on that then, team? That we would... Yes. Member Mello.
I think it's important for those who are listening on, when offenses are created, usually you look on the mode of trial and you also look on the jurisdiction in which the offense is triable. And there are rules around those matters. So a special statutory summary jurisdiction can be granted and can take the matter at a high level. But generally, if Parliament makes an offense triable in the parish court, there is a jurisdictional limit unless Parliament sets it outside of the limit by way of a special provision.
at one point, there is a little bit of confusion in the jurisdiction. We have an old set of provisions that allow for fine and or imprisonment. At one time, the jurisdiction was going away from that, and they're asking to go back to it. But a rationale has been given for the request, and I think we may wish to consider it. If you provide for a penalty, the penalty must be sufficient to deter the act that you're saying, if done, would amount to a crime. And really, the ask for increase in the monetary penalty has to be considered in the same way that we consider whether a limit that is set at one time continue to be effective at another time. BESFM is saying that in respect of the failure to disclose, their rationale is that the reason for non-filing can be the very root of the corruption that they're seeking to unearth and dislodge. So I think the Solicitor General was saying that a rationale had not been given. It's for us to consider whether that is itself a rationale, but I think we also have to look at the matter a little more widely in respect of disqualification. I'll come back to that.
Right. So, Madam Narrator, I think we had inadvertently omitted the contribution from the Permanent Secretary's Board. So it's very short, so I could just read that for you to benefit, right? So the recommendation in relation to Section 43(1)(a) and C, and 43(2)(a), and all other sections relating to fines, that it is recommended that a review of all fines referred to in the Act be conducted. So the Permanent Secretary is suggesting a full review of all the fines that are in that Act. It also recommended that close attention be given to the fine and penalty associated with Section 43(2) and 56(3)(b based on the gravity of the acts. I think that in a way, the discussions that we have been having have sought to treat with that in a broad way. In fact, the comment from Member Campbell, and certainly that from the SC, are in line with a broader look at the whole system, and indeed recommendations seem to be coming with regards to whether the fines as they are, with the penalties as they are, isn't indeed sufficient. I'd like to hear from members in that regard. Yes, Member Guy.
The question you're asking, Chair, is it that we seek to do what the Permanent Secretary's Board is right. recommending?
And I think that somehow we have been doing that.
We have been doing that, but not in a sort of formal structure.
Correct.
And it goes in line with what the SG was suggesting.
And also Member Campbell.
Right.
Yes. In which case, what is the position we take? Is it then that we would say that we would not accept these recommendations because the section itself covers the areas adequately? Is that what we're saying? Because if not, then we will have to decide what level of review is to be done with regards to the fine. One recommendation which came from the excuse me, the Jamaicans for Justice was that it goes to 2 million. Another reference didn't take note of the fact that the the section require not just the payment of the fine, but the completion of the declaration.
Might I suggest, therefore, that the recommendation would be that we get an urgent matrix of all the fines within the current legislation for a review by the committee. So we put those two on hold, the two recommendations, and agree with the Permanent Secretary's Review Board's recommendation.
Members, the proposal by Member Guy is that we accept the Permanent Secretary's recommendation for a full review of all the fines within that area, and for that research to be done and information presented to the committee for the next meeting for us to make a full determination on this one.
Prior to the next meeting, Chair, so we'll have a look at it.
Yes, indeed.
So we can
do we have a
informed.
consensus on that? Yes, we do. Okay, thank you. Next item, 44, Member Malahou Fort.
Expenses incurred in preparation of statutory declaration, tax deductible. There is no recommendation in respect of that. And just to quickly, all right, 45, powers of the Director of Investigation generally in relation to investigations. I don't see any recommendation in respect of that. We go to 46. We have no recommendations for amendment. 47, no recommendations. 48. 47 from the PS Board.
47, we have a recommendation.
Consideration of matter.
From the Permanent Secretaries.
I'm coming.
May I read that for you then? As I'm not sure if you have opened that other side of the matrix.
Yes.
And it's a very short recommendation, actually. So may I read it? In relation to section 47.2, we recommend that the Director of Investigation give consideration to whether the complaint or the information submitted to him is supported by evidence of probative value when determining to investigate a matter.
Well, 47 provides that the Director of Investigation shall, upon receipt of a matter pursuant to section 46, examine the matter in order to determine whether or not an investigation in relation to the matter is warranted.
Yes.
And
I think that's why the point is made with
so
regards to probative
we recommend that the Director
value.
of Investigation give consideration. So that recommendation is for applying the provision, not for amending it.
Right.
That the Director of Investigation would have regard to this provision.
Correct.
Chair.
Yes, Member.
I am of the opinion that what the 47 recommendation from the Permanent Secretary's Board is actually, though not spelled out, but is actually covered by what 47 gives to the Director of Investigation. Because 2 says, shall in turn whether to investigate a matter that has been referred to him, consider 1, the seriousness of the conduct to which the matter relates, B, whether or not the matter is frivolous or vexatious. You know, that basically, to me, they would have to do their due diligence to determine prior to investigation whether it's a matter that really requires their action in.
Well, I think the Member Malahou Ford made the point that what the permanent secretary of the committee seem to be suggesting is that the director be strengthened in his effort to ensure that the investigations are serious by whomever is making it before. Exactly. Absolutely.
But Chair, you know, if I may.
No, I think, sorry, I think that point needs to be looked at from the point of view of what triggers an investigation from a third party by the IC. And the issue, for example, of illicit enrichment is triggered a lot by third party complaints and or information concerning declarants. So I think what the permanent secretary's body is actually saying here is that the director involved must be satisfied fully that these complaints which come in are strong, powerful, and valuable enough to worth and merit their investigation. And I think that we can relate to that. Yes, sorry.
If you think that emphasis is required, and I would have a challenge with that, except to say that I'm still of the view that it is covered here, but I would have no objection to it being included.
Right. No, I don't think the issue is that it's probably not covered. I think perhaps what the permanent secretary wants a little more belt and braces, just to make sure.
In other words, what they're really saying, not even willy-nilly.
Yes.
Undertaking, but that's obvious.
Okay, so we not detain ourselves any further with that. We can move on. We would accept what the permanent secretary team said here, excuse me, and move on to 48. Yes, I'm sorry.
So just to be clear, the committee is agreeing that the provision should be amended?
No.
No, I just want to make sure so I have the right note.
No, it's not to be amended, no.
Oh.
I think that what is inherent in this suggestion is that that 47 be administered with greater
Common sense.
Yes, sense of what is substantial and not really accepting just because somebody sent you a complaint that it merits investigation, but that the complaint itself be examined carefully to determine whether it has merit.
But that makes sense. I mean,
yeah, I think, but for the permanent secretaries themselves to have a concern, it must mean that something triggered it.
And I accept that the permanent secretary's board would not simply just put that there frivolously.
Absolutely.
But it would seem to me that as has been said, any complaint would have to be interrogated before you get to the level of investigation. But perhaps the remedy or the thing we could do to create some safeguards here is the question of the punishment for making a false complaint about somebody, which I do think the Act already does. I don't know if we would want to look at that just to make sure that it still is sufficient to provide some safeguard against a person who would make a false complaint about a potential declarant.
Or
an existing declarant, rather.
Yes. Member Charles.
Thank you, Chair. And following what King's Counsel, Mrs. Marlene Aldred, said a while ago, I think the question that she's raising, we as a committee have to look on. And not to belabor it, though, right? But when the permanent secretaries raise the issue of probative value, I am imagining that it is raised with them having a full understanding of what the clause says. So they would have seen that the clause speaks to the three issues of seriousness of conduct to which the matter relates, whether or not the matter is frivolous or vexatious, etc., etc. But property value, from my memory of law school, would speak to whether the harm would be outweighed or outweighs the usefulness. If there's more harm to the issue than usefulness, then you exclude it. So is it that the permanent secretaries are suggesting that something be introduced to the legislation that defines that? That is what I think. That is what is being asked of us. Meaning, do you want to, property value, and council can guide me if I'm along the right pathway, King's Council 100. Is it that the property value concept is being integrated as another clause to say where the property value or doesn't outweigh the prejudicial, that it be excluded? That's the question.
Thank you, Member Charles. I think Mr. Foreman wants to. Yes.
His mic.
There we go. Right. I just wanted some further clarification on the decision. So is it that the committee agrees with the statement and in its report will express that agreement, but it's not proposing any amendments to the legislation in this respect?
Well, the recommendation didn't ask for an amendment.
Okay.
Oh,
Which is the point. The recommendation seemed to suggest a comment, and perhaps for us to be aware to ensure that in the report a strong position is taken on that. That is my interpretation from here, but I'm subject to guidance. And perhaps we may want to look back, members, at the discussion that was had with the permanent secretary team that came before us. Perhaps, Ms. Douglas, you might want to revisit that particular discussion so we really get to understand what was behind the recommendation here. Because sometimes we forget the circumstances of that moment which gave rise to the recommendation itself. And if we had that before us, it could help us to better understand how to deal with it at this time. So I would ask her to do that research for us for the next meeting.
Can I just ask a pointed question to on this issue? Is it in terms of the technical perspective, would it be required for us to introduce anything, in your view, technically, into this clause in order to capture what the permanent secretaries have said and that what we have agreed with? Or is it sufficient as it is from your technical perspective in terms of the 2ABC as it is currently constructed? A question to you, Solicitor General.
Yeah, repeat. Just repeat quickly. So distracted. Who's the person behind CPC?
Being guided on a matter here, which is useful, is that, right, just before, Ms. Douglas advised me that the Permanent Secretary Board didn't actually come before us, that they declined. What they did was to send a written submission.
Chairman,
So we could continue then, and just before you, I think Mr. Foreman wanted to respond.
my mic was on, Chairman.
Right. Yes. Chair, on the face of it, as was pointed out earlier, subsection 2B of section 47, I think contemplates that the decision maker is going to address their mind to the quality of the complaint, that is made in order to determine whether it's frivolous or vexatious. I suppose it may be possible to add further language. I don't know what that language would be.
No.
To say something about, to include particular types of considerations. I perhaps would want the benefit of the drafters' experience on that.
Chairman,
I don't know.
Is there any? What we're saying is, I don't know if there's any language, if that is what is required, a language that would give a greater emphasis on, because the probative element of which Member Charles referenced, and indeed the Permanent Secretary's reference, is valuable, because you don't want a investigation to commence, and the value of that will be more deleterious to the declarant than the outcome itself. And that's always the painful part of it every time, you know. So I think if we can find a language that would give them the sense that do not commence until, because if you do.
At what stage though? You understand what I'm saying?
No.
And I think that is why the question was raised, even though I don't know why SG doesn't want to.
No, I think, Chairman, can I come in here?
Sorry, member, can you release your microphone so that
I have no
Chuck,
control. It is you who has
you're still on the floor. Member Chuck.
Okay.
Member Charles is still on the floor.
Go ahead.
Go ahead, Member Charles. Go ahead, Member Charles.
The mics are malfunctioning because mine was on as well.
Okay, all right, good. So go ahead now.
When you examine it carefully, Chairman, there's some merit in what the Permanent Secretary's Board is saying. Allegations are made of corruption of public officials. If the Integrity Commission say that they have these allegations, or it may well be that having got the allegation, they're proceeding to investigate and report to Parliament in their annual report that they're investigating X number of parliamentarians and Y number of public officials. There might be no merit in these allegations. What the Permanent Secretary Board is saying is before you announce that you're investigating, at least there should be some evidence that the allegations have some probative value. Now, it could, in fact, all of this could be avoided, Chairman, if the Integrity Commission stick or comply with Section 53, that they don't report investigation, they just investigate and report, which is what I have been saying repeatedly. So that to the extent that they do an investigation, it is obvious that having got an allegation and they are going to investigate. Now, if there's no probative value as they move forward, it is abandoned.
Right.
But what I think the Permanent Secretary Board is concerned about, in my view, is that when you start investigating, you announce that you have these numbers of investigations to do, when behind many of them, there's no merit. And that is what the Permanent Secretary Board is saying. And Section 47 and what is being alleged can be avoided if the IC stop announcing that they're investigating. Just investigate and report.
So I just wanted to check something else, whether or not there's any provision in the Act which provides an obligation on the Commission to report on all investigations that it's doing based on all the information that may be coming to it. In other words, is there a provision which
You'd be
says...
talking about Section 36, Chairman, but the provisions in Section 36 are they're very specific. So it speaks to what report can be submitted to Parliament and when.
And when.
And we have discussed ad nauseum Section 36(3), which gives the Commission the right at any time to submit a report relating to any particular matter, which in the opinion of the Commission requires the attention of Parliament. But if I can just go back a little bit to speak specifically, and I want to read the wording. I know Member Malahoo Fort had read it, what the permanent secretaries are asking to be considered. In relation to Section 47(2), we recommend that the Director of Investigation give consideration to whether the complaint or information submitted to him is supported by evidence of probative value when determining to investigate a matter. Yes, I've slowed down my reading for a purpose. Because, Chairman, I think we must be very cautious that the scheme of the Integrity Commission has 3 roles that operate separately. There is a reason why the legislation was written in the way it was written, so that the Director of Complaints receives declarations, receives complaints. At the stage when a complaint becomes a matter requiring investigation, it becomes the purview not of the Director of Complaints, but of the Director of Investigations. The duty of the Director of Investigations is not to determine evidentiary value and the weight of evidence, is to investigate and issue his findings. Those findings are what are considered by the Director of Corruption Prosecution to determine if the matter is to be prosecuted. So we have to be very careful, and I think I imbibe the concern of the Permanent Secretary's Board, but we have to be careful because it is not the Director of Investigation who must weigh his findings. He is simply to investigate and make findings, conclusions about those findings, and those conclusions would go to whether or not the matter is a matter to be tried, lie in the purview of the Director of Corruption Prosecution. And we must be very careful about how we mingle and muddle the 3 roles.
Right. So, Member Malahoo Fort.
Chairman, Member Golden has in fact touched on the point that I wanted to make, and I'll just amplify by saying that after an investigation is done, if there is sufficient evidence in the view of the Director of Investigation that a recommendation to the Director of Corruption Prosecutions is warranted, the matter is referred there. The determination as to whether to prefer a charge is at that stage more appropriately weighed than at the stage of the Director of Investigation. I believe that any complaint received is to be investigated. The extent of the investigation will be determined by a number of things. The scheme has different directorship with different roles separated by Chinese walls. And so I think not everything to be considered administratively is placed in a legislation. And I think that has to be borne in mind. The concern of the Permanent Secretary Board seems to stem from how things are announced after a certain point. But all matters, all complaints would have to be investigated. And investigation doesn't mean that it leads to a referral for prosecution or that it results in a prosecution at all, in the same way that prosecution does not inevitably lead to a conviction. So I believe insofar as what is to be taken into account by the director of investigation, that is set out at 47. Yes.
The real concern, Chair.
So, yeah.
The real concern.
I think Member Golden got it right. The complaint comes. The complaint has to be
So it begins with the director of information.
Or information.
Yes.
That there is an allegation of corruption or, illicit enrichment or wrongdoing, whatever the case may be. The director of investigation will have to check to see if there's merit in it. And if there's merit and it shows that some wrongdoing may be there, pass on to the director of corruption proceedings. The concern is that we don't really should detain ourselves on this. We expect the IC to go through that process. What I think is the real concern of the board, the Permanent Secretary Board, keep that internally. Do what you have to do. Investigate. And at the end of the day, you report. But what has happened in the last couple of years, Chairman, is that in their annual report, they're reporting investigations. That they're doing investigations, and we don't know if these investigations will be meritorious.
Yes.
Or it's just complaints that they've got, because, they have told us that these investigations are based on complaints, or they have these complaints. Don't report that. Report on your investigation.
So I think the challenge here is what the learned KC indicated. What is it that is required of us? Yes, is it that they are saying we should make an amendment, or is it a language that is being required here to suggest that the greatest level of care is taken? I don't know, but more so, are they seeking to find some remedy in the event that, the investigation led to a damage to the reputation of someone without, hard facts being laid at the first instance? That at the end of the day, the facts came out, but in the interim, the individual has been damaged and destroyed. I think that is probably the germ of the consideration here, and whether a language could be created to remedy that situation. I'm not sure. Member Campbell?
Chairman, can I just address that point, if I might? Because Member Chuck is sort of drilling down what the concern of the Permanent Secretary's Board may be. And I just want to remind us that what the Integrity Commission report on, we have mandated by virtue of the schedule of the Act. And so and this is the right time for it, if it is, as Member Chuck is suggesting, that we have asked them to report on matters that carry a certain unfairness based on the stage of that reporting, then we should take a look at that. So, for instance, the annual report of the Commission and the matters that must be reported in that annual report under the second schedule require details with respect to matters investigated by the Commission, the number of investigations commenced but not finally dealt with during the financial year in question, average time taken to deal with complaints, actual time taken to investigate any matter in respect of which a report is made. So we have asked them to report the number of investigations. Now, I don't know that they're reporting the number of complaints. I would have to re-examine the annual report to remind myself. But as far as I'm aware, they're required to report the number of investigations, but it's not that every complaint or every piece of information that comes to them is something that they're required to report. So if perhaps we could look at that, I'm looking at Mr. Minister now, just to double check, in the reporting, in the annual reporting, is it the investigations that are being reported, or are we seeing reports of numbers of complaints or what we're calling information submitted to the Commission? Because I think it is the complaints and information that the board is referring to. And if that is being reported, then I can see where the angst might be. But under the statute as it exists now, it's not required to be reported. Only the investigations that are commenced are required.
So can we ask then for that bit of research to be done so we can be guided at the next meeting? Because I think, to determine what it is that the report from the Commission provides, whether it provides a detail of the number of complaints that have come in, the number that have been investigated, and so on. Yes?
I am not in their annual report. Obviously, they have to be fulsome and say that they have 60 investigations under considerations. Where I think we have to be careful about, can you imagine if in their annual report they say we have 60 investigations, of which so many are against parliamentarians and 2 against permanent secretaries? Can you imagine the damage that could do to the permanent secretary board chairman? So one has to be very careful how detailed you report an investigation. I have no difficulty. In their annual report, they say they have 60 or 200 investigations being conducted. But when you start getting into specificity, no, they do. In 2023, they said 6 parliamentarians. They don't have to say 6.
I think members, my guidance a while ago might be useful in the context of getting from our council what the report actually says, so we can be guided better. Because I think we're speculating a bit in terms of what might have been included. Yes.
In that speculation, if I may, Council, in that speculation, I think also what we could seek to determine whether we need to go there is to get an idea as to how many complaints, if we could get from the IC, how many complaints they have received and how many investigations as a result of those complaints. So say, for example, there are 200 complaints and they only found that they need to do just 30, right? It probably would also negate us acting on what the PS board is actually asking. But I also want us to look at subsection 3, Chair, in 47.
47.
It says the Director of Investigation may, for the purposes of performing the function under this section, A, make such preliminary inquiries as maybe he considers necessary, right? Which goes back to what Member Chuck was saying, that it would be common sense to do that,
yes,
right? And if we want to reinforce the point now to indicate what we are concerned about coming from the permanent secretary, then language probably could be added there. I don't know.
I think the Act may need some restructuring to make clear that certain provisions are of general application. Right now, some of them are put under certain parts, which may give the impression and can be interpreted as relating to those parts. So section 36, which speaks to report, and I'm just pointing to this section in response to something Member Chuck said. Section 36, subsection 4, provides that a report submitted to Parliament shall exclude matters that may, if included, prejudice proceedings in relation to any matter referred therein, and shall not contain any communications which is subject to legal professional privilege. You jump over, bear in mind the restriction on publication at 53(3) until the tabling in Parliament of a report under 36. Matters under investigation by the Director of Investigation or any other party involved in such investigation shall be kept confidential until the tabling. So after the matter is tabled, it can be spoken about. But in respect of what is submitted in the report, the law does provide for exclusion of matters that may prejudice proceedings.
Except the inferences. Yes.
Too much. I think the concern of the Permanent Secretary Board, as it is certainly of parliamentarians, certainly this parliamentarian, is in your report. Nothing is wrong in saying these investigations are taking place. But when you start being specific to say we're investigating 1 or 10 permanent secretaries for whatever, then it immediately, brings in question what were the nature of these complaints or investigations being conducted. So all that one is saying is that you're not, the act is clear. When the Director of Investigation get a complaint, investigate. And when you investigate, you use your common sense to see whether or not you continue. But as far as I'm concerned, you don't report that you're investigating, which in my mind, cause reputational damage. Because from you say you're investigating a permanent secretary or a parliamentarian, it questions
any category of people.
Once you start categorizing, you put that body of persons into question, which is exactly what has happened over the past 2 years.
All right. So I think, team, we've really spent a little while on this. Let me ask our legal counsel from the Parliament to make her comment. And yes, I'm coming to you.
Thank you, Chair, and thank you, members. Based on the question asked by Member Golding Campbell, I looked to the last report that I could find online, and that being the annual report for 2023 to 2024. There is a section of the report that deals with anti-corruption activities, and that is found on page 12 of the said report referenced. There you will find a subheading, Complaints and Information, and there it says 172 complaints and information were received or identified for assessment by the Commission during the reporting period. 19 of the complaints or information assessed were referred to the Director of Investigation. 85 were closed and 7 were kept in view. The Commission prioritized the more serious complaints or information received during the reporting period. With that said, the report does indicate the number of complaints that it has for the relevant period and whether the number of complaints based on what was referred to the Director of Investigations, how many of those complaints were actually investigated or closed.
But read on it. It spoke about 6 parliamentarians and 28 other public officials.
Right, so that would be found on page 13 of the report. What it did in fact say is that there were 6 reports tabled in the Houses of Parliament. So I'm seeing where under declarations and financial investigations and contract procurement or corruption investigations, it says, during the 2023 to 2024 financial year, a total of 20 complaints were advanced for investigation. 19 of those investigations were made by referrals from the Information and Complaints Division, and the other investigation was initiated by the Director of Investigation. 6 reports were tabled in the Houses of Parliament over the referenced period. Of the 20 complaints referred for investigation by the unit, 14 matters were pursued. All cases being pursued are ongoing and are at varying stages of the investigation process, pursuant to Section 33 of the Integrity Commission Act. I am not seeing in that section a reference to there being 6 parliamentarians being investigated, but what I have found in the document thus far is that there were 6 reports tabled in Parliament. I am just doing a quick search, so I'll just ask if it is that you could just give me your indulgence for a few.
I did ask, though, that you research for the next meeting. It's just that your efficiencies allowed you to come back faster than I had anticipated. So in order to satisfy what Member Chuck is requiring of you, please take a deeper look, and then at the next meeting we could have that information if it is possible. Now, I think we've really exhausted this discussion. We're searching, we're still searching, I think, to find a language perhaps that could reinforce what the essence of this probative value is all about. I think that's the key in this discussion, to ensure that once the information goes out at all, right, about any declarant, right, the substance of it is strong enough to not create an impression to damage the person, right, whilst the investigation is still going on. I think that's the point that really wants to be addressed here. Member, we'll have 2 more comments and then we'll go to 48. Member Malahou-Fort and Member Charles, in that order.
I wanted to remind that the Learned Solicitor General attend the meetings of the Permanent Secretary Board, and may be better placed to just clarify what is the ask of the Permanent Secretary Board if it has not yet come into the fore, but also to remind that the scheme of the law does speak to parliamentarians and other public officials. I think we continue to struggle about what is in the law. The review is to look at how the law has worked, whether it has worked as it was intended to work, and how to make it better without diluting the provisions.
Absolutely.
So we have to take into account the law that we pass ourselves, and to ensure that there is clarity and that those who are to enforce the law can do so in a way that would achieve the goals of the law and without raising concerns that would cause their own approach to be perceived as lacking integrity or being unjust or overzealous.
Is going to detain you quite a bit. All right. So thank you, Member Malahou-Fort. Member Charles, are you still interested in the final
I was just
intervention?
You know, I might have caused an avalanche by my one question, but in closing, I just want to indicate I asked the question of the Solicitor General or colleagues from her office because of their technical capacity and ability to be able to evaluate and guide us. And I believe we got the guidance from Mr. Foreman, who said that in his view, which I'm assuming is the view of the Solicitor General, that the clause would have been sufficient. So I think they've guided us in that regard. So we could probably advance.
Thank you. Just to respond to Minister Malahoo for it, because of the role I play here, I did not participate in the discussions that the Permanent Secretaries Board had when they were deliberating. So they had a small committee deliberate and then they reported, but I did not participate in it. And just to say, just as how we do in other laws, we don't always go into a lot of detail about how a decision maker is to undertake their functions, because there's Wensbury's principles. And everybody always has a right to approach the Constitutional Court for judicial review, because a decision maker is not supposed to act irrationally or unreasonably. And some of what is being discussed would suggest to me that you're looking at when irrational or unreasonable decisions that can't be defended at full court, are taken. So whether or not you put those provisions in, they apply, and you have to read them into the law. So I'm just saying, even without anything else, once the law gives anybody these kinds of powers, quasi-judicial, they have to act reasonably. They cannot be irrational in how they take their decisions.
Okay, so the ruling on this one is that we take note of the Permanent Secretary's recommendation. I can't elevate it to a higher position than that the committee has taken note of the recommendation. 48, member. 48, which deals with the power to require attendance before Director of Investigation.
The Jamaica lands, they expressed concern about subsections 5 and 6 of section 48, and they are of the view that they seem to contradict section 7 subsection 8, same person in our movement. It is believed that the public officials should be forced to declare anything that is true, and that it only makes sense to have protection against being forced to declare anything that is false. Right. Norman Manley Law School's recommendations are as follows. It is proposed that section 17 subsection 1 and section 48 be amended to allow for virtual attendance at the meetings and proceedings of the Commission. Section 48 subsection 6 is to be amended to partially exclude the privilege against self-incrimination. They suggest that in place of the blanket preservation of the privilege, section 48 subsection 6 be amended to ensure that the section does not hinder the provision of evidence by a person to the Commission for the purpose of an investigation and the prosecution of an offense under the Act and under the Corruption Prevention Act. But nevertheless, preserve the privilege so that neither the information, notification, nor document was given or required, nor the information, notification, or document provided above shall be admissible in any civil or criminal proceedings against the person other than an offense under the Act, the Corruption Prevention Act, or the Perjury Act. The clarity of that is lost on me, perhaps because of how it is set out. But let us see.
Of 47.
Well, we can.
48 is very clear.
The first part of the recommendation is to allow for virtual attendance instead of in person. I think perhaps that's taking into account the experience coming out of the COVID pandemic. And since there are predictions for other such matters, whether that should be expressly provided for in the law, in the same way that any document required to be submitted can be submitted electronically. Any attendance that is required can be done virtually. I think we are appropriate.
But yes, course. Because consideration has to be given to where the technology is going. And indeed, we are going to find more and more, that our presence are not necessarily going to be physical. It's going to be substantial by virtue of content and what is said. So I wouldn't have a difficulty with that.
So let's see.
But I think the area that we need to look at is where it speaks to section 48(6). Nothing in this section shall be deemed to remove the right of a person against self-incrimination. And also 5, which says no person shall, for the purpose of an investigation, be compelled to give any evidence or produce documents which are subject to legal professional privilege, or which he otherwise could not be compelled to give or produce in proceedings in any court of law.
Before you get there, reading Section 17, does it expressly forbid them to have a virtual meeting? Because it says, meetings of the Commission shall be held at time and place as the majority of the Commission shall decide. Notwithstanding subsection, the chairman shall call a meeting if requested in writing to do so by at least 3 commissioners, and that they're to meet at least 6 times per year. The fact that it does, yes, I mean, can we get some advice on that from the legal minded persons? I mean, does it exclude a virtual meeting by this language that is here?
Who can have virtual attendance? The commissioners?
So as it relates to the virtual meeting, our experience was we had to do some amendments, like for instance, the Companies Act, because when it didn't expressly provide for it, you couldn't really read it in that it was allowing for virtual meetings. And in fact, before the law was amended, companies had to approach the court to get an order from the court to allow them to have their AGMs virtually. And I do believe we have made some amendments to other laws to allow for a virtual or hybrid option.
But in this particular case, is the legislation written just like the other ones that you had to intervene?
Well, the way it's written, it suggests that you are someone to attend, as in that you are to physically appear. And in fact, that is how they operate, where when they issue their summons, you have to physically attend. And
but this is speaking to the meeting of the commissioners, not necessarily for somebody who is brought before the commission.
Which section are you looking at?
17.
Oh, yeah, it's 17. I was looking at 40.
No, it was based on the fact that the recommendation was that we should look at 17 and 48 be amended to include for virtual attendance. I'm just looking at 17 and seeking to find out whether this particular writing or phrasing of the legislation would allow for a virtual meeting or hybrid, or for avoidance of doubt, you'd like to put it in?
Based on the experience we had during COVID, I would suggest that you actually put it in and make it very clear. Yes.
Right. So I think we have some consensus around that. Because even here in Parliament, we have to move for suspension of the standing orders to allow for our meetings to be held with virtual involvement. So it is a perceived position throughout because the laws at the time didn't anticipate any virtual attendance. So, so as to avoid anyone saying, well, you must attend, and you are in a position where you can't because you are somewhere else, maybe in another country, you know, and so as not to appear as though you have in any way negated your responsibility to be able to attend virtually should be accepted. And I think the law can be so adjusted. So we'll accept that. What was the other, the one from Norman Manley? That's okay? Okay, so Minister Chuck, can you do 49? Yes, there is something from Norman Manley at 49. Yes. Norman Manley is proposing that Section 49 to be amended to provide for substituted service.
Before you move on, this virtual thing, is it for both 17 and 48?
Yes.
For both?
Yes.
48 is specifically requesting them to come to the commission.
No, but I know, but they are saying is that you can do it virtually as well. That is really what it is saying. Yeah. Members, just a small recommittal. Clarity sought in relation to the virtual attendance, whether it relates to any sitting that the Commission requires of you, that it could be either virtual or physical. Yes? Let's be clear.
I would suggest you give them the option to make rules about it because, for instance, it depends. They have different types of hearings under this law, including even the commissioners themselves. I'm just thinking that maybe it would be better to give them the flexibility to make rules about how they would conduct, whether a virtual or a hybrid space, and what can be done virtually, and maybe what can't be done virtually, for instance.
Or perhaps to say under what condition they would accept virtual.
But to give them the power to make these rules, and then these rules would be something that persons would be made aware of.
So we need to construct something which allows for virtual presence and physical presence, with the proviso that the Commission could then determine what are the rules governing virtual and physical presence. Yes?
No problem.
Okay, very well. So thanks for the guidance. Well done. Yes, I know, but this is what we just did a while ago.
No, this is permanent secretaries board. They are making reference to when legal privilege is protected, self-incrimination is not protected. But they put it on.
No, but 48.5 says, listen, this is what 48.5 says. 48.5 says, no person shall, for the purpose of investigation, be compelled, which I read that. So he says 48. This is what the law says, you know, that you shall not be compelled. So how is you not protected?
No, they say is protected to legal professional privilege, but there's no protection for self-incrimination. So it's
no, but nothing in this section shall be deemed to remove the right to a person against self-incrimination.
I'm not sure that is only that's on the permanent secretaries.
Right, so they probably didn't see this section. So it's perfect. That's why I don't push it. All right, okay. Very well.
We read 49 from the Norman Manley Law School. The recommendation in this proposed that section 49.2 be amended to provide for substituted service. Isn't this normal? I mean, service includes substituted service. The act should be amended to allow for substituted service as contemplated by section 49.2, where personal service is not reasonably practicable. The amendment may, for example, require the Commission to make an application to the court for an order to serve the summons by alternative methods of service. Electronic means of service may be contemplated. I'm not too sure we need to amend it, Chairman. You know, if
that is in keeping with the earlier recommendation from them with regards to virtual.
Yes.
I think it's probably trying to modernize the provision there in the law, which would take into account the state of technology at this time versus when the law was created and crafted in the first instance. But can we hear from SG?
SG, when you have service, I mean service of documents, isn't substituted service contemplated? I mean, and even if, huh?
No, I was just saying that's court, and this is not court. But can you just give me, I'm not as quick as, look at 2. A summons under this section shall be as set out in the 5th schedule and shall be served on a person mentioned therein by delivering to him a copy thereof or by substituted service.
Huh?
Or by substituted service as may be prescribed. So they would just need to prescribe it.
Right, so it's there. We go to 50, Chairman. Nothing at 50, and then we go 51, and this is from the Integrity Commission itself. Recommendation, it is recommended that due consideration be given to the inclusion of an offense in circumstances where the work of the Director of Investigation in accordance with Section 51 is, Roman 1, obstructed or hindered, Roman 2, where a person fails to comply with the Director's lawful requirement, and Roman 3, where a person willfully makes a false statement to mislead or misleads or attempts to mislead the Director of Investigation of any other person in execution of his function under the Integrity Commission Act 2017. Rationale. Despite the CAST powers, the Commission notes that unlike Section 43(1)(b), which creates an offense for failure to provide information required by the Director of Information and Complaints, there is no similar provision in law or sanction in relation to the Director of Investigation upon which he can rely in execution of the function under Section 51 of the Integrity Commission Act 2017. In absence of such provision restricts the dissuasive and timely remedies that should be available to the Director of Investigation having regard to the entitlement stated in the Act. There's a converse view from the Permanent Secretary's Board. It is our opinion that Section 51(1)(b) of the Act provides the Director of Investigation with too wide a power to determine how information relating to the grant, issue, suspension, or revocation of contracts, licenses are to be provided to the Integrity Commission. We propose that a limitation be imposed on the discretionary power provided to the Director under this provision. So those are the two. And
Chairman, I share the view that Section 51 may need to be reworded.
Reworded in the context of the recommendation from the IC, or?
Well, you know, there's a certain learned colleague who normally put it this way: the best way to avoid abuse is not to invite it in the first place. Abuse in the exercise of any power. Always have to clearly provide what it is that is to be done.
So in the context of it, we accept the recommendation from the IC, subject to the appropriate wording by the Solicitor General's Department, yes? Well, it's you who have to help us with that.
She's saying it's not the Solicitor General's Department,
It's the
but
AG.
the Attorney General's
The Attorney
Chambers.
General's Chambers, yes. Do forgive the reference. The Attorney General's Chambers.
Excuse me, Chair, just to clarify that you're asking for assistance in terms of the wording of the obstruction offense, because that's what the Integrity Commission have asked for, an offense to deal with obstruction and failure to comply and willful. So,
Still 51.
so is it that's what the committee agrees?
Yes, that the wording is needing changes. Am I correct, Member Malahufort?
51, I'm sorry.
51.
It was not that I was speaking to, but in respect of the IC's ask, they're saying where a person fails to comply with a lawful requirement and where a person willfully makes a false statement to mislead or attempt to mislead the director in the execution of his function, then that should be an offense. But the failure to comply cannot be stated as broadly as that. Normally it is without reasonable cause. So there is a particular way, because a failure to comply may not necessarily be with a criminal intent. And so if you notice, generally, those kinds of offenses are without reasonable cause.
May I just continue? The permanent secretaries had some board in relation to 51. They continued where they, in bracket, they actually respond. The statement consisting of so many pages is true to the best of my knowledge and belief, and I make it knowing that if it is tendered in evidence, I shall be liable to prosecution if I have willfully stated anything that I know to be false or do not believe to be true. The information in the QCA report would not be within the personal knowledge of the permanent secretary, except to the extent that such knowledge would have been derived from the information provided by other departments of the respective ministry. Notwithstanding, the IC would be relying on the information in the report for the purpose of proving the truth of its content. Accordingly, it could be argued that information provided to the IC in the report would be hearsay, and it would be unfair to hold a permanent secretary personally liable for same. According to sections 19(1) to 3 of the Public Bodies Management and Accountability Act, 19(1), a director or officer shall not be liable for breach of duty under section 17(1) if he relies in good faith on a report or reports 16B of an attorney at law, accountant, engineer, valuer, or any other person whose profession gives authority to a statement made by him, including any director or officer who has provided such report in his professional capacity. Subsection 2, a director or officer of a public body shall not be in breach of his duty under section 17(1) if he believed in the existence of information which, if true, would render the directors or officer's exercise of care, diligence, and skill in the performance of his duty to be reasonable, prudent. 3, for the purposes of this section, a director or officer shall be deemed to have acted with due care, diligence, and skill, where in the absence of fraud or bad faith, the director or officer reasonably relied in good faith on documents relating to the affairs of the public body, including financial statements, reports of experts, or on information presented by other directors, or where appropriate, other officers or professionals. Consequently, we propose that this statement in the report be amended to read, this statement consisting of so many pages is true to the best of my knowledge and belief. Further, we recommend that the QCA report be included as scheduled in the Act and as in a prescribed form. In other words, what the Permanent Secretary's Board is saying that if it turns out that they reporting on matters from their officers or from their department, and it turned out not to be true or to be exact, that they should not be liable for prosecution because they are relying on the professional expertise of those who put that. So I would say, Chairman, that what they're proposing, the statement of so many pages is true to the best of my knowledge and belief. I see nothing wrong with that. Huh? Yeah.
But I think that the reliance on what could be regarded as a competent authority there, should be sufficient. If I seek the advice of a lawyer and an accountant and an engineer and so on, and that's their best advice at which they affix their signature and their seal, then the responsibility of the veracity of the statement should shift from me to them.
Exactly.
Chair.
Yes.
Chair. There is the point that was first discussed by the IC, which we haven't really explored, and that they are seeking to have the Director of Investigation enjoy some similar powers. Director of Investigation, enjoy similar powers as the Director of Information and Complaint as it relates to their work. Because if you look back at 43, and we spoke about it earlier, about the fines that they are seeking to have increased. My read of 51 is that if an offense is committed and in circumstances where the work of the Director of Investigation in accordance with Section 51 is obstructed or hindered, or where a person fails, etc., that some punishment be given to that person. And if you look at 51, which we are looking at now, there is nothing there, as far as my read is, to prevent anybody or punish anybody from giving the Director of Investigation information or acceding to the request of the Director of Information. So we need to deal with that point as well as the one coming from the Permanent Secretary. But what the IC is asking is similar provisions for the Director of Investigation as is in the legislation for Director of Complaints.
But here now, the Permanent Secretary Board is adding a caveat. Is saying, fine, but where the information is provided, right?
And what should be further considered.
That provision, yes, has to be taken.
I think we note them, Chairman, for further consideration and adoption. Both.
Yes. All right. Shall we hear from SE? And then.
Thank you. I would like to also, however, bring to your attention Section 45 of the Act. Section 45 of the Act gives the Director of Investigation the power to summon witnesses, compel the production of documents and information, do all things which are necessary for the purposes of conducting an investigation. And then it also gives the Director of Investigation such power, authority, and privileges that are given to persons under the Revenue Administration Act. And then I go to Section 48. Section 48, 2. where the Director of Investigation has the power to summon persons on oath, and the proceedings are deemed to be a judicial proceedings within the meaning of Section 4 of the Perjury Act.
So they have the power.
And then the Director of Investigation also has the same powers as a commissioner under the Commissions of Inquiry Act as it relates to attendance and examination of witnesses, production of documents, and everything that falls under all of those 11 big B, C, D, E, F, G, H, I, J, K, L of that act, which is to apply mutatis mutandis. They have all the powers.
So they don't need any more under this section? Chairman, we move on. Yes. It's already there. The next section, 53, Chairman, is one. Is that, we just did what, 51 or 52?
52. So just for the record, we have not accepted that recommendation, right, because the powers exist already. Okay, fine.
They have wider powers elsewhere. Now, 52, Chairman, from the Permanent Secretary's Board, the following are recommendations for Section 51. In Section 52, 1B, amend to include the word revocation on the second reference among the factors. In relation to prescribed licenses, the circumstances of the grant, issue, suspension, or revocation of prescribed licenses, so as to ensure that such grant, issue, suspension, or revocation does not involve any impropriety, irregularity, or breach of any applicable law relating to procurement. In subsection 52, 2C, recommend that consideration be given, including other categories, for example, proprietary information specific to international trade and or commercial agreements.
Decision. Just trying to, for my own note taking, the Permanent Secretary's Board's recommendations for Section 51 were deferred?
No, we accepted.
They were accepted?
Yes.
Okay.
Yeah. And I think we should just accept what they say in 52 too. No, Chairman, 53 is going to... And 52. Because they... Hey, warn me. The next section, the Permanent Secretary's Board. This is the one in Turks and Caicos. This is careful.
Team, we can accept,
right.
Yes, the recommendation.
No, Section 53, Chairman, is going to be a troublesome clause for us to give some good consideration.
Right.
But
so in that context, we are at 12:30, and
we can go till 1 o'clock, right?
Right. Just to indicate that we're at 12:30 p.m. and we need to vacate the building so that the parliamentary arrangements can be put in place.
I would like to read the Permanent Secretary.
So you may read, but I would want to suggest that we would not make a decision on this until the next meeting. The next meeting we would have...
No, Section 53.
Sorry.
We accept.
Yeah, we accept. Sorry, Member Chuck is on the floor.
No, but...
But we can't be dealt with today because of the time. I don't think this is too difficult to be read through and accept or disagree. It's a simple
let's read through and then we decide after I read through.
Member Chuck, I'm speaking.
I'm just guiding members to understand
based on this, it's a very simple recommendation here. Yes. It has gone through the Privy Council. Either we say yes or no.
Okay.
So we can read through and we can accept or reject.
Well, let's read it first.
I have no difficulty with
Thank
that.
you, Chairman.
What I was trying to guide you is to just to say we are on a little time constraint.
Thank you, thank you.
All right. I would like to read it, Chairman, because this is a very important recommendation from the Permanent Secretaries Board. It is a matter that the SG has brought up before us on a few occasions. I read Section 53. It has been recommended.
No, hold on. Just to note, Section 53 is very involved. We have a lot of recommendations from almost every one of the witnesses that came before us. So I know it is going to detain us a little bit, and I really want to give a fulsome review of it, you know, and because we are at that hour of the afternoon, I'm suggesting that we...
No, let's read through the first then, Chairman.
Read through it all?
Yes.
That take you to 1 o'clock.
Well, I would like to read the Permanent Secretaries Board recommendation. No. 53, Chairman, the Permanent Secretaries Board says, it is being recommended that Section 78 and at 53, the Permanent Secretaries Board, and 53.2 be reviewed in light of the principles of natural justice. The powers afforded the IC are too wide-ranging and seem unfettered. The UK Privy Council ruled in December 2021 that the Turks and Caicos Integrity Commission only had the power to demand documents from third parties such as banks after formal investigations have been initiated is of note. The Privy Council in its judgment stated that such powers did not exist in the normal course of the Commission's functions, such as reviewing statutory declarations by public officials. Reference is made to Section 14 of the Prevention of Corruption Act 2021 for Barbados that introduces the concept of disclosure orders. These orders are to be issued by a judge in chambers. When the judge is satisfied that the requirements are fulfilled, the judge makes the order authorizing the investigative officer to give to any person who has information relevant to an investigation notice in writing to answer any question or providing any information documents specified in the document. It is recommended that the Integrity Commission Act be amended consistent with the ruling by the UK Privy Council in the Turks and Caicos matter to require that information be sought from third-party institutions be done with the consent of the public official, and to introduce a requirement for disclosure orders issued by a judge in chambers after careful consideration of the evidence supplied by the Integrity Commission and only in furtherance of an investigation. Due notice having been served on the public official that an investigation is being pursued. It is noted that Sections 711 and subsection 48.5 provide for protection on the grounds of legal professional privilege regarding the disclosure of certain matters. However, both provisions fail to provide protection on the grounds of the right against self-incrimination. That's from the Permanent Secretaries Board, Chairman, which is...
Yes, I just wanted to note that beyond what the Permanent Secretaries' recommendations are and their notes, we have notes from the Integrity Commission on that subject. We have from the Jamaica for Justice, we have Jamaica Land, we have the Ministry of Finance and Public Service, we have Best FM, we have a private sector organization, we have National Integrity Commission, National Integrity Action, then we have Jamaica Accountability, Meet-a-Port, a whole range of recommendations.
You want to leave those until...
So we would defer...
No, but Chairman, let's discuss the Permanent Secretaries Board recommendation.
We defer discussions on this to the next meeting, which, as I indicate to you, we are planning to have meetings every week between now and the end of February to complete not just the matrix, but to prepare the report for the next session of Parliament. So, if I would rule that we truncate the discussions on the matrix at this time.
Okay.
And to allow for Member Malahou Ford to make the recommendation concerning the minutes.
Chairman, earlier I had asked that the minutes of the last meeting be deferred to a later time in today's meeting, but from all indications, more time would be needed to review and consider the minutes. So I would ask that members just review the minutes in time for the next meeting so that we do not have to defer them if the timeline is going to be kept of completing the work before this session is prorogued, and also that the minutes of this meeting be sent in time to be reviewed ahead.
Thank you very much. The motion is before the committee. Do we have a confirmation and acceptance of the proposal? Yes. Thank you very much, member. Members, just to indicate that, we've done some good work. The matrix is almost completed. Our next meeting will be the 4th of February at the same time, yes. And we are hoping that we should, if not complete the matrix, then be very close to it. And then we can begin to go back now to the areas for which we sought further and better particulars from both our technical team as well as for our own
we're on 53
discussions.
We haven't completed it.
Thank you very much, and this meeting is now adjourned.
Jamaica Eye will play a part in increasing your public safety.
Jamaica Eye is part of an island-wide network of camera surveillance systems designed to increase the safety of you, our citizens. If you have a camera system outside your home or office facing a public space, log on to jamaicaeye.gov.jm today. Jamaica Eye, we're all connected. The Ministry of National Security, creating a safer and prosperous Jamaica.
Good things are happening in Jamaica. Our unemployment remains the lowest it has ever been, which means more Jamaicans are working and can provide for themselves and their families. Your government is building Jamaica.
Cook it up and make we steam it. Fresh so me need it, tilapia a real fish. Cook it up and make we roast it. Farm fresh so me need it, tilapia a real fish. Grow smart at the best part. Food for thought so me have to eat smart. Easy catch, fully net. A tilapia so you don't know what's next. Cook it up and make we fry it. Fresh so me need it, tilapia a real fish. Bring home the best in freshwater fish. High content of vitamin B3, protein and potassium. Tilapia, simple, healthy, delicious.
Denise Williams here, inviting you to join us on Financially Focused, the ultimate destination for go-getters who are ready to take the step-by-step actions to master your finances and create a family legacy. Tune in, watch, take notes, and participate to discover the strategies of our expert guests who provide invaluable guidance and powerful coaching tools to supercharge your financial journey.
Tune in to Financially Focused, Thursdays at 8:30 p.m. only on PBCJ, the People's Station.
Can you imagine getting a marketable skill for free? Your government has made it possible for anyone wanting to learn a skill to get free training through the Heart NSTA Trust. Learn a new skill and expand your horizons.
Jamaicans, practice proper disposal of garbage, and if items can be reused, recycle them. We all have a part to play in protecting our environment from pollution. We are building Jamaica.
Jamaica, home of the resilient, passionate and hard-working. A people and a nation who have achieved and defied all odds, working to keep their economy growing, their country thriving, from investments made in innovative opportunities and exports demanded globally. We have a vision now within our grasp, where Jamaica becomes the place of choice to live, work, raise families, and do business. We will not let go of this vision. We will grow. We will overcome these challenging times and look to the future with hope and positivity. These are special times. The world as we know it has changed, but home will always be in our hearts. And in Jamaica, you can always find a home. Think you know Jamaica? Look again. You will be surprised.
Good things are happening in Jamaica. Our unemployment remains the lowest it has ever been, which means more Jamaicans are working and can provide for themselves and their families. Your government is building Jamaica.
Jamaica's economy is in the best shape ever. Everybody yard and abroad talk about it. Your government is investing in our hospitals, parks, community clinics, roads, and water infrastructure.